I'm Harold Jordan. I am the Senior Policy Advocate at the ACLU of Pennsylvania. I've been here just a little more than 9 years.
Equity at its best.
This is part one of our interview with Harold Jordan of the American Civil Liberties Union of Pennsylvania, and the question was, what civil rights do students have in public education?
There are certain rights that all students have, and no matter what state you live in, what city you live in, if you're a public school student, you have certain rights to free expression. When I say free expression, some control over what you can say and what you can wear and what you can print, your right to have student publications and things of that sort. Now, there are certain limitations that go with that. That is that they can't be disruptive in some real material way of the educational process, of the mission of the school and the activities of the educational activities of the school. And school districts sometimes get that wrong. They try to say that anything a student does that they don't like, whether it's for students to publish a newspaper article that criticizes a school policy or wearing a t-shirt to protest something, sometimes school districts get it wrong and they try to say, well, you can't do that because that's disruptive. But what the Supreme Court means by disruptive is something much more serious than that, that makes it impossible for a school to function in its educational mission. So it's got to be something more robust. So there are certain kind of general rights that all students have with certain limitations in mind. I mean, some other limitations are that school can say you can't use profanity in your expression. So for example, if you have a newspaper with profanity in it, the school district can limit what you can do with that newspaper or your distribution of that in school. You can't do certain things like that cross certain boundaries. But all students in public schools have certain rights. And there are, in addition, rights to be treated fairly. Now, those play out differently. The specifics of how those are to be enforced play out differently with different groups of students. The clearest and cleanest example is with students with disabilities. There is a law called the Individuals with Disabilities Education Act. That is a federal law. It's been on the books for 40 years that grants certain kinds of protections to students who are classified, that is, after having been tested and given an individualized education plan, who are classified as students with disabilities under this law, which is known as IDEA. And that means, for example, if there is an attempt to punish a student, to remove a student from school, to transfer a student, or do some kind of a disciplinary action, there first has to be a determination that the student's behavior, determination of whether that student's behavior is a result of that disability, a reflection of disability, or something else. And so that's just an example of the type of protection that exists in federal law. There are limits on how long a student can be excluded from school and certain other kinds of processes too. There are exceptions to that too. Obviously, things having to do with guns and weapons are generally exceptions to most kind of student protection policies. But that's probably the best and cleanest and most universal example of a student right for students with disabilities. Race, gender, sexual orientation is a little bit more complicated. And of course, in a general sense, those students have the right to be treated fairly, right? How that works out and what is considered unfair treatment and who enforces it is a little bit more complicated. The issue is something that's come up in a very public and visible way a lot in the last 10 years, especially during the era of the Obama administration, where the Department of Education was a lot more specific about what federal civil laws require of schools and what it means to not discriminate against a student based on race, gender, or sexual orientation. Now, the specific legal requirements are different for those groups, but the general idea is that students have to be treated fairly and be treated the same as other students who are not in those categories. That's the general idea. Whether it has to do with access to school programs, admission to school, and discipline. The big issue that the Obama administration focused on, the Obama administration's education department focused on, was discipline and disparities, inequalities, and how students were treated in the disciplinary arena. Whether it's a situation like two students doing the same thing, but the student of one color is treated one way and another, and there's a systematic pattern of that, or in other kinds of ways where special rules are made up by school officials to prohibit certain kinds of hair and clothing styles, especially when there's not a good, sound educational reason for that rule, and that there may be other ways to accomplish the stated goal of the rule that don't result in harming one group of students by race or hue and another, versus another group of students. And similarly with gender. Women in schools should have access to all of the same programs and facilities as men and to be treated fairly. That also means not being sexually harassed. It means that the school districts have a responsibility to intervene in situations where unequal and unfair treatment is brought to their attention.
It goes back to the very old saying, if you can treat someone like you would like to be treated yourself, things go very, very well. Not easy, it will just go well.